I was watching the General Court Martial in Uganda yesterday, and I was shocked. I was shocked. I would tell you that even the village elders session, when we have issues at home, we usually meet at the village elders compound. We talk. I'm very sure that we call it Mukasa. We either call it Mukasa or we call it Liguru in Luhya. I would say that the general court martial that was conducted, especially yesterday, holistically, just wastage of intellectualism. But I want to talk about yesterday alone. If anybody watching that would not believe it, we have already said that, and after watching that, I've come to believe that Uganda, during Idi Amin's time, the judicial system during Idi Amin's time was far more. Idi Amin and Colonel Isaac Maliamungu, they were better off than what is happening in Uganda now. They are better off because if you look at the proceedings, let me take an example. There was the proceeding of the kangaroo court of Luwum and two others. At least there was a procedure. Yeah? And you see the president was, and the current president of Uganda graduated in the 70s in Dar es Salaam University. and right now those people who are there are very different. We can see that Uganda, there are three types of courts, which is unique, which is not, I've never heard of it anywhere. They have the court martials, which they level it at different levels. They have a court martial like these epics. It's called General Court Martial, which is headed by Brigadier General Robert Freeman Mugabe. And then we have regional court martials, which are in like Karamojong area. There is a regional court martial there. Southern, let's say they are around 4 or 5. Northern, Eastern, Western, Central, such a thing. Those are headed by colonels. And then we have they go on that various levels. Now the general court martial is headed by a brigadier general. His name is Robert Freeman Mugabe. He was born in 1965, so that is not his name. Because 1965, nobody in Uganda knew somebody called Robert Mugabe. Nobody in East Africa knew anybody called Robert Mugabe. Robert Mugabe started being heard in the 70s. So this is somebody who had his name, but when he joined NRA in Luero Triangle, he adopted the name Robert Mugabe, and it stuck. So that is how it is. I will not talk about civilian courts because civilian courts, everybody knows about it. I'll talk about police courts. I've never heard of any other place in the world where we have something called police courts. I'm a former police officer, so I would say that in the Kenya police, we have something that is called orderly room proceedings. Orderly room proceedings, those are the proceedings that were used to terminate my work. Now, orderly room proceeding is just like a court, but it is an ad hoc. it is an ad hoc court. It is an ad hoc court that when a police officer uh, behaves in such a way um, that he needs disciplinary proceedings similar to a court, then orderly room, just like the word, you are supposed to be made orderly. Yeah. Orderly room proceedings are initiated, and once you are convicted, uh, or not even convicted, once the case is ended, it is disbanded until another one does. The purpose of it being ad hoc, it means that very rare do you find that there is need for police officers to have disciplinary action. In Kenya, when do we have that orderly room proceedings? Orderly room proceedings are done when your seniors feel that you should be sacked, or when you may commit a criminal offense and you're taken to court and you win the case. And if you win the case, you win it in such a way that the court says, in court in Kenya or any other court, you're supposed to be convicted beyond reasonable doubts. But if there is reasonable doubts, the court will say that you most probably did commit the offense. You most probably committed the offense. It's only that nobody can prove beyond reasonable doubt. Let me give you an example. There is this, just one example. There is this case of Kisumu where somebody took a picture of a young boy taunting a police officer with a monkey dance. The police officer went and shot that boy. And not only did he shoot that boy dead, he went there and kicked him to see if he's still alive. And then we saw the way the body was. He said he believed that he's dead. Now, looking at the body structure, because he was a son of a former police inspector, so he was employed when he's shorter than ordinary police officers. If you look at the body structure, because he had dressed in a riot gear, so riot gear, you have an helmet similar to the border people. So you could not recognize him by face. You would only recognize him by body structure, his walking style, and anything. So when he was taken to court, it was discovered that when there is a Amara, the fellow who gives out guns, the Amara was giving out guns, and in a haste, because Kisumu usually is associated with a lot of riots. Hopefully in the future it will not be there. So in the haste of giving out firearms, instead of the Amara writing, let's say, the serial number of the gun 831, he wrote 813. He wrote 813 instead of 831 in the arm movement register. And when he went to write a statement and it was typed that way. But when ballistic experts did a search on the gun, they discovered that the gun number 831 is the one that fired bullets. But according to the records at Kisumu police station, the gun that was given to this police officer was 813. But the gun that killed the protester was one is 831 and another one is 813. So that one technically the constable was saved. Now some people say that the sergeant did that deliberately to save the constable. I say no, because when the sergeant was giving, I've been a police officer. I know how armor is when people are doing that. The boy should just thank his gods. The boy should thank his gods. So it is obvious from the evidence that whatever was given before court he is the one, but according to the Kenyan law, he has to be convicted beyond reasonable doubts. So in such a case, he is taken to police procedure, orderly room proceedings, where his work is terminated. He is dismissed without benefits. He is dismissed without benefit. That is, but to find a country like Uganda with a full-time police court, imagine there is a senior superintendent, several superintendents, and several assistant superintendents forming a tribunal there permanently waiting to convict police officers. It shows that the rate of indiscipline among the Ugandan police is very high if you compare it to Kenyan police. The other thing is also, now I've talked about it is just another name of a military and a court martial, but strictly dealing with the police. So in Uganda, they have two court martials, but this other one, they call it police court, which specifically deals with the police. In the 2 years ago, when Brigadier General Gabriel Freeman Mugabe was taking over as the head of General Court Martial, he was told that there's a problem, a backload of cases, meaning that at the time when he was taking over as in charge of General Court Martial, there was over 100 pending cases. There were over 100 pending cases, so you can see how it is. But the funny thing is that the two accused, this one I've said so, but I'll repeat, the two accused, one is a retired colonel. In military court martials, you cannot, world over, you cannot take a person to charge him in a court martial if he's a retired military person. Unless and until, for example, if new evidence comes up that when he was still in active services, he committed something that is an offense under the, so he can only be charged with a military offense of an offense that he did when he was in active service, and evidence have just cropped up. Evidence have just cropped up. But here is one of the accused is a former army colonel, no longer in active service. And the second one, his co-accused, says that he has never even been a Boy Scout. They are being charged. Now, if you say so, especially on this other second accused, you ask yourself now, if everybody is now being taken to the court martial, then why do we have civilian courts in Uganda? Another thing is that Uganda, they wanted to overthrow Uganda having two pistols in Westlands, Nairobi, Riverside Drive, which is 450 kilometers away from Ugandan border. Now that is general. Let me talk about yesterday. Yesterday, there was a delay in the people in starting the court. There was a delay first because the nani Mother Karua was to get a license. Mother Karua was to get a temporary license, so she has to go to the court of to the High Court in Uganda to get the temporary license. So first of all, they had to go there, and for her to get the court license, they found themselves, the military found themselves in a very funny situation, in a situation where it was a lose-lose, because they were saying, and you could even hear the court advocate was saying that Mother Karua was a foreign advocate, and the people shouted. You know, any court proceedings, you should they should not change conditions. Now, Dr. John Haminwa had appeared in a civil case where he was defending Museveni. So there was a question of, now the charge that is being charged is a charge of a criminal, not only criminal, but it is, if he is found guilty, Uganda, they still have a death penalty, and not just death penalty. If the court convicts him, he will be shot by a rifle. So people are saying, if Museveni could be represented by Haminwa during what do you call, an election petition, which is a civil nature, what about this fellow who is and the other thing was Kenyan Law Society had sent out a word. Kenyan Law Society sent out a word saying that this thing will have a ripple effect, that in future Ugandan lawyers may not practice in other East African countries. Not only Ugandan lawyers, even lawyers from other countries. You know, it needs only, in a chain, you only need to disconnect one and the whole chain falls off your bicycle. So if you do that, Tanzanian lawyer will not appear in a Kenyan court. A Kenyan lawyer will not appear in a South Sudan court, and so on and so forth. So that is what made them change their mind. Another thing I've noticed, which I'm not trying to say that the Kenyan law is or Kenyan constitution is superior. In Kenya, licensing of lawyers is done by the law society. And if you have issues with a lawyer, you want him or her to be deregistered, you report him to her to the Law Society of Kenya. Then the Law Society will decide whether to suspend or even cancel his license. But then you find that in Uganda, there is another thing that is called law commission or something in the High Court that licenses people, licenses lawyers. So that is a uniqueness. I cannot say that ours is better than theirs, although I've expressed elsewhere that even the religious Kenyans, we should have a religious society of Kenya similar to the Law Society of Kenya, where they'll take care of things such as that one. The funny thing I noticed also is that the court martial, the panel, including the judge advocate, who is by nature a lawyer. Now, in other countries, judge advocate is usually a magistrate, a civilian magistrate, whose work is only to direct. Actually, it's not even hard. Usually, he gives opinion. He gives opinion to the panel. I know this because in Kenya, we had that thing when I was young in 1982, where we had several court magistrates. One was called Omondi Tunya. And that is the time when Wetangula became famous because he was involved in that. In many jurisdictions, judge advocate is usually a magistrate from the civilian court who gives advice. I don't know where they got this idea. You see, there was a lot of arguments. The what do you call, the judge advocate, the way you look at him, he doesn't behave as if he's addressing civilians who are advocates. He behaves like a drill instructor in college. If you don't know what a drill instructor is, that person who teaches askaris how to march. So he looked at and talks to them with a face of whatever. And he has been told several times that you should not even address us. You are supposed to advise the chair. And first of all, he's supposed to be a civilian. The second thing, if it is a must that he has to be a military lawyer, then I don't know who came up with this idea of having a judge advocate of the same rank with the court martial chairman. It gives it a bit different thing, because one thing, you may even be of the same rank. There is promotion and appointment. You may be of the same rank, but somebody who is of your, I saw that with the police. For example, uh, the deputy PPO the deputy PPO Northeastern was a senior superintendent, and the OCPD Garissa was a senior superintendent. I can also give the deputy commandant railways was a senior superintendent, and the OCPD Port Mombasa, it used to be called Harbor, was a senior superintendent. But the senior superintendent, who is deputy commandant or the deputy PPO, is senior to this one, although they don't salute each other, but that is that. In a disciplined services, you find that a brigadier general who is a court martial has already entered the courtroom and sat, and then, but then you see Uganda is, maybe because they evolved from a gorilla welfare, they still think they are still gorillas. You are in a room with a brigadier general, that is court advocate. Another brigadier general of the same rank as him enters, and everybody stands up except the court advocate. They stand up and give him his respect. If the judge advocate was a rank below, or even several ranks below him, he would have stood with other people. Now you see, that is the embarrassment that is there. In police, not in, okay, police imeniingia. In disciplined forces, if you are with a senior superintendent, and like the OCPD Garissa, and the deputy PPO Northeastern comes, who is the same, you don't salute that one. You have already saluted this one. But you see, that is the embarrassment that came with having two people. The other thing I've said, and I'll repeat saying, is that this court advocate has assumed two ranks. He's behaving like he's the chief prosecutor. At the same time, he's behaving as if he's the chair. He should not even address anybody. He is supposed to tell, for example, let me give, yes, you can talk a week, but let me give an example. Mother Wangari Karua was addressing the General Court Martial as a tribunal. Then it came to the opinion of the judge advocate that he told Mother Karua that this is a complete court, it is not a tribunal. Next time you call this one a tribunal, you stand a chance of being charged with contempt of court. That is his duty. He was right, but he was not supposed to address Mother Wangari Karua. He was supposed to seek for permission from the court martial chair. Said, chair, let me give you an advice. And the chair would listen to him. He would say, can you tell the learned counsel that referring to this court martial as a tribunal may lead her to be prosecuted for contempt of court. Then after saying that, the chair of the court martial would behave as though Mother Wangari Karua did not hear that. Then the chair would say, the chair would address Mother Wangari Karua by saying, anytime you call that, we will treat it as contempt of court. So that is And that is why I say even calling this thing, what do you call? Calling it even a kangaroo court is giving a kangaroo a bad name. This one should be called Matope Court. Now I had reached a place where I was saying entering the court martial. It took a long time. Apart from searches, of course, entering such a place, you have to look for people. Somebody may have a tear gas, somebody may have a grenade, somebody may just those people who have been appearing there and coming back. It should take minutes. It is only Mother Wangare Karua whose clearance would have taken 5 minutes more. Everybody else would have taken 5 minutes. Mother Wangare could take 10 minutes. The 5 extra minutes would have been uh, those military police at the gate were supposed to go and verify whether the temporary license is genuine or whatever. They would go to the court martial, tell them that there is such a thing or whatever, and then the general court martial would have connected with the Ugandan law council to verify is it true and whatever in a phone call. That is why others would have taken 3 to 5, and Mother Karua would have taken 8 to 12 minutes. But they delayed entering the court martial, and then the court martial itself chose 3 defense lawyers. These people had chosen several lawyers. They had even involved non-Ugandan lawyers, including Mother Karua, whom they are even aware that she could not present herself in the other time because she had no practicing certificate in Uganda. So she was supposed to do what? She was supposed to get a temporary, and theirs was just to verify that. But they decided that now the court itself decided that they are going to have 3 lawyers. That is like they must have looked at the weakest lawyers among those people and said that is that. When the court martial was asked why choose those 3 and not why the 31 or whatever, they said that there is no way they can know that Kizza Besigye and his co-accused wanted to be represented by this because there is no evidence and whatever. That there is no written instructions whatever. First of all, there are some things which are obvious. If you look at the proceedings that were happening the other time, the last time they met, they had sat down, and one of the reasons why it was postponed was that Mother Karua decided, and Kizza Besigye's team decided that even though it is not good to have a Christmas and New Year behind bars, but they wanted first of all to clear with the Law Council of Uganda. The court martial would have just asked for Mother Karua to verify. Last time we were here, unless the note that they used the last time, they used it to maybe light some jiko at home, because the proceedings previously had been that Mother Karua was to go to the Law Council of Uganda to get. So they would have asked Mother Karua, did you get the license or didn't you get the license? That is the only thing they would have done. But instead of confirming that she has a temporary license or not, they are saying that no, we are having 3. And the 2 accused should have a written in a letter telling the court that the following people. Now, one of the mayor of Uganda, the Kampala, who is deputizing Mother Karua, said, but you see, there is a problem. Luzira prison. Now, Luzira prison is like Kamiti. Luzira prison, getting access to to these people is a problem. Now, even bringing them here, when we want to talk to them aside, you don't give us, so you are accusing us. It is just like Moi. Kenyans who are old enough will remember. Moi took Matiba. Matiba was very fine. Actually, the time when Matiba was detained, he was going to climb Mount Everest. So he was physically fit. They took him to prison. Matiba became physically, after stroke, he could not write with his hand. So they were saying that Matiba's, what do you call, Matiba's petition should have Matiba's signature. Another thing also, there was a case where Kibaki had sued Moi because of, and they said, but you did not hand him, you did not hand over the your summons to. The court was saying that Kibaki was supposed to hand over personally to Moi. I was to hand over to Moi the court summons. But Kibaki was saying, how can you go to State House, tell them that you want to meet Moi to give him the summons, and then you... So the court said, no, the case is thrown out because you did not. And that is why in Kenya we changed the constitution and law, whereby serving, we would even require you to place it in a public place. You're supposed to place it in 3 newspapers with circulation. It will be seen as if you have served. Now that is what is, well, that is where Uganda is. That is where Uganda is. Before let me side talk a bit. You see, in Kenya we're having a lot of problems, including the latest being abduction and whatever. But compared to Uganda, you know, when your child is making a lot of noise, oh, sijui nini, watu wanasema wewe hujui kuchunga mtoto. Kuna mtoto mwingine akisema tu mwe, the father gets out a rungu. So when you see Ugandans quiet, na sisi tunapiga kelele, don't say that they are better off at sijui kwa nini hawapigi kelele. No, ni ile kupigwa, wanapigwa na baba yao to an extent that anything happening they don't talk. They don't talk. So they don't make noise. Na sisi tukiguzwa kidogo, that is how it is. Another thing that the court judge, the judge advocate said, which was funny, of which was also learning there, is that he said, actually it seems that the military police were getting instructions from him. The delay that they had at the gate, it seems it was, because even the panel itself, starting from the chair and all the people there, they didn't have an idea of what was happening out there. But the court advocate knew everything that was happening. So it shows that the military police were getting instructions from the court advocate, which is unprocedural. The military police are supposed to get instructions from the presiding officer of the court martial. So you're saying that the lawyers could not be accepted because they don't have practicing. They do not have practicing licenses. But then he was being told, and which is funny because he's a military officer, unless Uganda. Anyway, I want to say this. I want to give you a very good example. If you are a Kenyan, you know somebody called Oswago. Oswago was the chief executive officer of the IEBC. Oswago joined the military as a lawyer. So he was a military lawyer. He retired and he started his own law firm. So in Kenya, we have such things. And for you to be a lawyer, there are 2 ways in the military sense in Kenya. There are those people who joined the military as lawyers, and then they were taken to the military police to handle such things. And they don't just, military lawyers are not just there for court martials. No. Anything. For the example, you are supposed to supply the military with cabbages, be for anything. Such things. You have to enter into, or you are supposed to construct a house for the military barracks. The military has to enter into a certain league or whatever. So their own military officers, um, major advocate, lieutenant colonel advocate, captain advocate, they advise the military on the suitability of the contract that you're entering. So for you to be, it seems in Uganda, your loyalty to Museveni is so high that hiyo law yako unaacha kando. Hiyo law yako unaacha kando. The way we were treated when we were recruits in Kiganjo, when I arrived at the gate, I was a form 6. So niliambiwa hiyo form 6 yako acha hapo kwa gate, utakuwa kurutu. Siku ile una pass out ndio utachukua hiyo form 6 yako uendelee nayo. So that is how it is that way. Because this fellow does not know, he's a lawyer, but he does not know that, or he knew it and he was just using that. He was saying that for you to practice here, you have to produce valid certificates. And he was told, first of all, I don't know why he decided that 3 lawyers ambao nafikiri, there is a lawyer saying that when you cross the river, you cross the shallowest place. So he must have chosen those 3 lawyers, knowing that those are the easy people to handle. But then even the 3 lawyers that he appointed for Kizza Besigye and his co-accused do not have a license, because according to Uganda, all law certificates are dated as per that year. So all lawyers in Uganda have certificates for 2024. But according to, because there are so many lawyers and the law commission has got to renew each year, they are allowed to use last year's certificates up to end of March. Now this fellow, how he chooses that these 3 lightweight lawyers to defend, the 3 lightweight lawyers to defend the accused, and their licenses are just like the others. I don't know where he got that idea. And then he decides that he will not accept the temporary. And he was saying, now you can go back to the law council to get letters to certify that that is how it is. We have something in law that I've forgotten the name, but it is called after effect. You cannot tell me that you'll accept my last year's certificate if I go back to get a letter certifying that. You could, in law, since that is something that has been happening, you do not make today's law. Like, for example, taking bang in Kenya is illegal. And then the courts sit down and say, starting from 1st January 2025, taking bang is accepted. You can take bang publicly. I'm only giving an example. You cannot go to court on 10th January and say, my case of bang, which is ongoing, you see, I was caught in December 2024 taking bang, and now that bang is now accepted, so please withdraw the case. No, you will be charged according to what was there at that time. The law, you are supposed to transport yourself, you are supposed to imaginarily up to the time of the committing of the crime. Now, when the lawyers came to the military court martial, the regulation was that they still use last year's certificates up to March. Now, if they have to go to again appear, if again they have to appear in subsequent appearances, then they should be told that in the next subsequent appearances, you either go to the law council, they hasten you, because you are few, they hasten the few of you to get licenses, or they give a verifying letter that you are allowed to do that. They say, no. He starts alone now, and starts and believes that. That was very funny. Uh, I saw what was happening. It is, lawyer Aaron Kiza was very active, And if you ask me, these things about having young boys something, he, he was, in fact, very many times the chair of the court martial was saying that, actually the chair has, Brigadier General Mugabe has said that he's, he's happy with the way the mayor, who is a lawyer, is conducting himself. He's also happy with the way Mother Karua is conducting herself. But uh, Aaron Kiza is hot-blooded, but he was appearing. He was on record appearing on that. But then a military police just blocked him from doing that. But instead of, I would have advised him to have, he should have told one of the lawyers who has already been cleared. And then when the proceedings would have started, the other lawyer would have brought it to attention of, but he started shouting and doing whatever. I think that is where Aaron Kiza went wrong. And then I noticed there was an RSM, a sergeant major, who was looking at what was happening, at the same time looking to the chair. I think the chair was out of sight, so I think the chair must have tipped him, because after looking looking at lawyer Aaron Kiza and looking at the chair, Brigadier General Mugabe, about 3 times, he came out and raised up his hand like a traffic police officer trying to tell Kiza to keep quiet. Kiza did not keep quiet, and then he gave this regimental sergeant major gave instructions to other military to manhandle him and place him in the dock the same way with Kiza BCJ. I said what followed was, even calling a kangaroo court is spoiling the name of a kangaroo court, because for justice to be done, one, we always fight for a swift justice, but this one was the swiftest of all. Within 15 minutes, this fellow had committed a crime, or so they said. And within 15 minutes, he was in the dock, and within 15 minutes, he had been convicted. And within 15 minutes, he had been convicted. For the first time in my life, I had a person being convicted and sent to a particular jail. Now, for Kenyans, assuming that you have been found guilty of any offense, and somebody says, I have convicted you, and you're going to go to Kodiaga prison. You're going to Kodiaga prison. I'm laughing because when a competent and compellant court with the jurisdiction convicts you, it is now upon the Commissioner General of Prison to decide which prison to place you in. Never. This is the first and hopefully the last time I've had somebody being sent to Kodiaga. I've convicted you and I'm sending you to Kodiaga for 9 months. The other thing that was wrong, you see, the chair of the court martial, Brigadier Gabriel Freeman Mugabe, was the complainant, because the lawyer misbehaved inside his court. The lawyer misbehaved inside his court, so he was the complainant. He was also the prosecutor, because when this fellow was taken to be there in the dock, there is nobody who read the charges to him, whatever. No, it is just the court martial who read the hey, bwana, Wakenya tunapata tabu, lakini we are in paradise, bwana. So this fellow orders a sergeant major to arrest this fellow. Arrest a civilian. He orders a warrant officer to order the military police to arrest him. The military police arrests him. He's taken to the dock within 5 minutes. After being taken to the dock within 5 minutes, the same complainant he did not even take a plea. A plea is where you are told, Aaron Kiza, you have been charged with creating disturbances according to section this and that of the Ugandan Penal Code, whatever. Do you plead guilty or not? Nothing of that sort. You are just told you have been doing that, and I've been warning you, and have been doing whatever. I have jailed you for how long was it? I can't. 9 months. To be taken to Kodiaga prison. eh? No option of fine. He's not even been told. There are supposed to be 3 examinations there. Examination. First of all, Aaron is supposed to be charged by another court. Well, it can be in the same courtroom, but another panel, whereby even somebody would present this panel and say, Your Honor, we were having this and this fellow, whatever, to a new panel. He was never taken to a new panel. Okay, even if he was taken to the same panel, they are supposed to read charges for him. You have been charged with creating disturbances. Are you guilty or not? And in other places, such a judge can, or the chair of he disqualifies himself because he was there and did whatever. He says that is what you call conflict of interest. I am the complainant. But you see, that is Uganda. That is Uganda. So, and I said it is even better for the period of Idi Amin and Isaac Lugonzo Maliamungu, because those are people who never saw a class, Form 1. Oh, in Uganda, the Form 1 is called S1, Secondary 1. Never saw Secondary 1 class. And so we can understand that, but we can't understand people who went to whatever. So you find that after he has been charged, there are 3 examinations. First of all, he's examined in chief. There is a time when he's told whatever. And then there is the cross-examination. Then there is the re-examination. None of the 3 happened. And even after being convicted, he was not even told whether his conviction. You see, as a former police inspector, I understand. If it was an orderly room proceeding, that one is understandable. It is there in the standing orders of the National Police Service in Kenya. That is where a senior police officer is disciplining a junior police officer. And that is not criminal, it is disciplinary, which goes to whatever. Even in the army, we have this thing that is called close quarter guard, where you are placed in the guard room. That one can happen. But for a criminal case involving a lawyer who is a civilian, there was no that. And even after conviction, one is there are 2 things that he was denied. He was denied mitigation, one, and he was even not told. He was not told about the appeal system. Eh? It reminds me of my younger days. I would be number 4 out of 25, and my father would really beat me up. But my siblings, one of them, I've even talked about her in another recording. She used to be number 21 out of 25 in her class. And my father would take her to Adam's Arcade to buy her ice cream. The cone, ile ice cream. Anyway, there is this type of ice cream which is snowy, something like that, where after you have used the ice cream, you eat the corn. It's made of bread. But me, the rare days when I would please my father, he would buy me the ice cream where after eating it, you still remain with a stick. I have three siblings: a brother, a sister, the one I'm saying, and a stepsister. Some people say I should not call her stepsister; I should call her half a sister. These people, father used to treat them with a kid's glove. But later I came to understand that father knew that some of us are very bright. So being number four, for a bright person, to him, that was a failure. But these people who are naturally thick-headed, he had already given up hope on them. He just wanted them to complete school. That is why you could be number four and you are beaten. And the other one would be number four out of 25 would be beaten. But the other one, actually, the three of them never even, they do not have even primary school certificates. They don't have. They do, if you ask them what did you get in primary, they will even not tell you. But what I'm trying to say is that for somebody bright, somebody educated, we expect you to perform or account yourself better than a person illiterate. If what is happening in Kampala was being done by Idi Amin and Isaac and Colonel Isaac Lugonzo Maliamungu, you would understand that because they never stepped in secondary one. But having people educated, some of them even having gone to Sandhurst, behaving the way these people are behaving, that is a shame. It's a shame to mankind, not even East Africans.